videos, we speak about consensus as the basis for contractual commitment, but that's not always the case. As you will see, in some instances you find that there is no consensus, in the sense that what would seem as consensus is defective for a number of reasons. So then the question would be, if the consensus is defective, then on what basis would the parties be held bound to the contract? These are the issues that we are looking at in this particular lesson. Just a revision of what we covered in the other lesson, where we were looking at consensus as true agreement. And we indicated that consensus is reached in the following circumstances. Parties share an intention to be bound. That's the first circumstance that's necessary. And then the parties share a common intention to be bound in respect of the matter being the subject of the agreement. And the intentions are clearly communicated between the parties. Now, when those factors are present, then we come to say that consensus has actually taken place. But as we have already indicated above, consensus is not the only source of contractual commitment. Parties may be bound on the basis of their own declarations, even in circumstances where consensus is, as we will see in the case where consensus, or rather what seems as consensus, is impaired by certain defects. Quite a number of factors vitiate or impair consensus. Well, they fall into two main classes. We have mistake as one of them, and then we have improperly obtained consensus as the second one. Now, under the class of improperly obtained consensus, we have misrepresentation, undue influence, as well as duress. Look at the picture that we have here. The gentleman whose hands are lifted up is certainly not able to exercise his will, judging from the fact that the other gentleman is pointing a firearm at him. So in certain circumstances, people may be forced, but we will talk a little more about that one later in the lesson. Now let's go on to the next step. Let's remind one another that mistake renders the agreement void, whilst the other factors render an agreement voidable. So what we are simply saying is that consent that is obtained on the basis of a mistake does not invalidate the agreement, but consensus that is reached on the basis of the other factors, such as misrepresentation, undue influence, and duress, it renders the agreement voidable. Now we want to look at the difference, or rather the distinction, between void and we say that an agreement is void when it is invalid, of no effect or consequence, and it's as good as not having been undertaken or concluded at all. It's as good as not having taken place at all. That's what we mean that it is void. It is of no consequence. But it's different from a voidable agreement, whereby you find that a valid agreement arises, but it becomes void when it is challenged by the party who has been wrongfully induced to conclude the contract. All the consequences of the contract attach to the voidable agreement until it is rescinded or cancelled by the party who alleges that manipulation took place. So what we are saying in the case of voidability is that a valid contract does arise, and if it is not challenged by the party who was wrongfully manipulated, it carries all the consequences of a valid contract. That's as far as voidability and void contracts are concerned. Now let us look at a mistake. What do we mean by mistake? Mistake is that error that maybe emanates from facts or a misinterpretation of a rule or some principle, but we'll talk about that one a little later on. In the moment, let's look at the effect of mistake. It vitiates or impairs consensus. It occurs when one of the parties misunderstands a material fact, a legal rule, or a principle relating to the proposed contract. Strict application of the consensus doctrine means that where there is no consensus, there is no contract. But you will agree with me that it leads to inequitable results, inequitable outcomes, because it would mean that even a party who has performed in terms of a contract may suffer a loss or something like that. And the other issue is only a reasonable mistake impairs contractual only a reasonable mistake impairs contractual commitment. An unreasonable mistake does not invalidate consent. Parties are held to their declarations and not to their intentions. So those are some of the effects of mistake on the contract. Now, we move on. We want to understand what the requirements are for a mistake to qualify as material mistake. A mistake relates to a fact, a legal rule, or a principle. That's very, very important to take note of. A fact or a principle must be material. That is the fact that gives rise to a mistake. And the mistake must be reasonable. So for a mistake to qualify as a material mistake in terms of which consensus is vitiated or invalidated, it must meet these three criteria. We said there is fact, legal rule, and principle. It must be material and it must be reasonable. Now let's, whereby we are saying the mistake concerns a material fact, legal rule, or a principle. Please take note that there are quite a number of circumstances where this arises. The mistake concerning the identity of the person, especially where identity of the person is an essential ingredient of the offer. For instance, in the case of job offers, if Mr. Smith, an employer, speaks to John via a telephone while he assumes that he is speaking to Peter, surely we may not conclude that Mr. Smith has offered the job to Peter. Because in the case of job offers, we know that the identity of the person is always an essential element. Remember, people have different competencies, and when a person is being employed, it is usually on the basis of the personal traits and competencies that Peter has, which may be different from those of John. Now, it's unlike in the case where one is purchasing a car through a specific salesperson. That one would not be considered a material fact, because if it's the same company that is selling that vehicle and you buy through one salesman instead of the other salesman, that would not be assumed, it should not be the basis to assume rather that the sale and the purchase are invalid. Now, the other element is mistake must concern the content of the intended contract. E.g., Tabo thinks he is selling his 2015 PQR sedan, while Sizo thinks that he is buying a 2016 Mercedes-Benz saloon car. In that case, surely there is a mistake, because what they are talking about, the vehicle that they are talking about, is not the same vehicle. Tabo is paying for one, meanwhile Sizo believes that the payment is in respect of the other. So that is a very significant mistake. It's a material mistake, because it concerns the content of the intended contract. Now, the mistake in connection with the consensus, or rather, the mistake in connection with the consequences that the law attaches to the agreement. For instance, 82-year-old William believes that he's buying a retirement home in a retirement village, which is designated for lifetime occupancy and not for sale. Now, as you can see, Mr. William here is laboring under a misconception that he has bought an apartment. But in actual fact, those apartments are not available for sale. And as far as the law is concerned, he is not competent to buy it because it is not available for sale. Which means this is a material mistake. Because what Mr. William believes to be doing is not valid in terms of the. So those are some of the elements to do with mistake. Let us look at these pictures here. We say that one person believes that he is buying, is selling a 2016 model. Look at the jalopy up there. And the other one believes he's buying this beautiful one at the bottom. Certainly, you can see that there's a mistake here. Both of the parties are mistaken in terms of the subject matter of the agreement. So it is a material mistake which invalidates or impairs consent, so to speak. Still on the same issue, we are looking at the fact or the principle against the test of reasonability. Is it reasonable to hold such a mistake? Now, a mistake is justifiable if it is based on an excusable error. For instance, you find that the mistake, one of the parties believes that he is offering one thing, and the other one unreasonably believes that he's being offered a different thing. Let's look at this. If the mistake is justifiable, parties are held to the contract on the basis of their declarations that they made. Now, the test for materiality principle is an objective one. We ask ourselves the question, would a reasonable person under the same circumstances have been deceived? Have a look at this. A person relying on the mistake must not be at fault. That's another step. A party must not have been negligent or careless, e.g., failing to read the terms of the contract before signing the contract. Those are some of the facts that must really be verified while in the process of establishing whether the principle is rather the mistake is reasonable or not reasonable. Let us look whereby you find that somebody believes that okay, just a minute, let's go back. Now, another form of contract is another form of defect in contract may come, as we have said, by way of improperly obtained consensus. We are saying consensus can be obtained in an improper way, as in the case of misrepresentation, duress, and improper or undue influence. Now, let us look at the picture that we have here. We have two people there. What do you think is the relationship between those two people? One is a doctor, and certainly the other one is a patient. Maybe as we progress with our discussion, just have those two at the back of your mind, because we shall revisit this image later on in the discussion. Now, we have the issue of misrepresentation as one of the major factors that impair consensus, vitiate it completely, invalidating it. An untrue statement concerning an existing fact made by one party, inducing the other party to conclude a contract, is a misrepresentation. It is the untrue statement made so as to induce the other party. In other words, that party would not conclude, or rather enter into that contract were it not for the false or misleading statement that is made by one of the parties. So the untrue statement may relate to the qualities or characteristics of the subject of the contract. And then, for us, as we look at this, to remember the essential attributes of misrepresentation. The untrue statement must relate to an existing fact or condition. In other words, if you are selling a house at a particular time and you do not know maybe that the roof is leaking, and then the buyer turns out later on to find that the roof is leaking, it may not be taken as having been an act of misrepresentation on the part of the person selling the house, because at that point the person selling the house did not speak about an existing condition. When he said that when he didn't mention the leaking roof, it wasn't because he was being deceptive or deliberately misrepresenting anything, but he was simply ignorant. So in that case, or suppose that the roof began to leak later on, much later, and the purchase had been done. So in that case, that would not be a misrepresentation. And we are saying concealment of facts may also constitute a sufficient act of misrepresentation. If you know that your house has a leaking roof and you don't disclose to the potential buyer, knowing very well that the roof has some leakages, then that's concealment of facts, and that's still an act of misrepresentation in itself. Now, the untrue statement made by one of the contracting parties to his agent, or rather, misrepresentation is an untrue statement made by one of the contracting parties, his agent, or someone in collusion with him, and then third-party statements do not constitute a misrepresentation. In other words, misrepresentation only exists between the two contracting parties when one of them makes a statement. And we have actually noted here that if the statement is made by one of the agents or somebody in collusion with that contracting party, then it constitutes misrepresentation. But if not, if it's just being made by an independent third party, then it is not, doesn't constitute a misrepresentation. Now, an unlawful misrepresentation is contrary to the norms of the specific community's sense of acceptable conduct. And the statement is for it to qualify as a misrepresentation, it must have induced the party to contract. In other words, there must be a causal link or a causal connection, a nexus between the statement and conclusion of the contract. In other words, if the other party went on to sign the contract, not because of what the statement had contained, but out of maybe an independent reason, then that would not constitute a misrepresentation. A false statement made intentionally, negligently, or innocently would still constitute a misrepresentation. So let's just have a think a little bit about what we have learned so far. What role does fault play in the determination of the claim for damages? Remember, owing to this misrepresentation, one of the parties may end up entering into a contract and prejudicing himself or herself in the process. Now, if it turns out, or if it becomes apparent later on that there was misrepresentation and the deceived party has suffered damages, how are the claims or the quantum of damages to be calculated? That's what you must think about. But take note that the issue of innocence is a very important factor in this particular in correction. We have another question here. We want to look at the effect of misrepresentation. The contract is not void, but only voidable at the instance of the deceived party. Remember that we have already spoken about voidability. We said that the deceived party must challenge the validity of the contract. If it decides not to, that is, if it decides to uphold the contract, then all the consequences of a contract will follow. But he is still not excluded from seeking damages in respect of any losses that may have been suffered. The deceived party may choose between upholding and rescinding the contract, and the innocent party may institute claims for delictual damages, and the degree of fault attributable to the misrepresenter determines the quantum of damages. Right. Now, what are the available forms of misrepresentation? We have intentional misrepresentation. Then there is negligent misrepresentation, as well as innocent misrepresentation. Now, let's begin with the intentional misrepresentation. It is made with an awareness that the statement is false. The statement made recklessly or carelessly without regard to the truth. The deceiving party intends to deceive and desires the outcome. So it constitutes a delict in actual sense, which means the party deceived may pursue delictual damages. Now let's look at negligent misrepresentation. It is a statement made negligently if the maker believes it to be true and does not take any steps to establish its veracity. Now this one differs from the previous one in the sense that in the case of intentional misrepresentation, there is an intention. But in the case of negligent misrepresentation, there is no intention. It's only a matter of not verifying, not going out to verify. Now, what about the issue of an innocent misrepresentation? The statement is made with the intention to induce the other party to conclude the contract by a person who does not intend to misrepresent. Take an example of somebody who is an innocent party without deliberately deceptive intention, advised by an expert who makes a false statement which induces a third party to conclude a contract. What examples do we have here? Imagine a trader who is involved, in selling works of art. he consults an expert, somebody who's known to be an expert in that field, regarding the origin of a certain piece of art, and then he is advised that the work available for sale actually belongs to, rather it was made by Picasso. And then this this trader displays the work of art and labels it as Picasso's authentic and original work. And it turns out that that is not true. And then a third person comes and purchases that work of art, only to discover later on that it was not the authentic work of Picasso. Does the third party have any recourse against the trader? Well, certainly he may have recourse, but not in the form of misrepresentation. Well, at least not in the form of malicious and deliberate misrepresentation, because the trader did not intend to mislead, but he was advised wrongfully by an expert. So he only communicated what the expert had advised him. In that case, we do not have misrepresentation, which is malicious and, or, which could result in intellectual damages, so to speak. Let us look at the issue of duress. Look at the picture that we have here. I'm sure you remember this from one of our previous slides. What is taking place there? Now, this explains exactly what duress is. We have an unlawful threat of harm or injury made by one party to another to cause the other party to contract with him. So the gentleman wants to conclude a contract, then he uses threat of some kind to induce the other party to conclude the contract. In this case, consent is made by means, is obtained by means of threat. He uses the threat, and then the resultant contract is voidable at the instance of the deceived party. And intellectual remedies are available whether the contract is rescinded or upheld, calculated on the basis of the victim's negative interest. These are very, very important facts to consider and to think about. Our question then is, what are the key requirements of duress? There is actual physical violence or reasonable fear of violence or damage. It's directed at the life, the bodily integrity of the person, or an immediate family member. This raises questions about hostage taking and contracts concluded as a result of, trying to pacify a hostage taker. Now, one of the requirements is that the threat must be imminent and inevitable. In other words, if there is a way of avoiding the carrying out of the threat, then one may not claim later on that they concluded a contract under duress. Now, the threat of the harm must be unlawful, an unlawful threat to, for instance, a threat to prosecute a person for an offense committed is not unlawful. Imagine that your neighbor committed an offense and you are aware that they have committed that offense, and then you tell them that you are going to report the matter to the police and have them prosecuted. Now, if a contract is concluded between you and that neighbor, pursuant to that what you call, pursuant to that threat, it cannot then be said to have been an unlawful threat, because in the first place a crime was committed for which a report must be made. Now, the duress must be exercised by a contracting party, not a third party. You cannot claim that you contracted under duress if the threat emanated from a person not connected at all to the party contracting with you. And there must be a causal connection between the threat and the conclusion of the contract. If it's just if the contract was concluded independently of any threat, then you may not argue that you were, forced into it, because that would not be true. And another thing, as we continue to talk about this duress, it is important to take note of the fact that the important element here is that duress takes away that freedom, or that freedom to make a will, to agree on something. Because if you are going to agree under a threat, surely that consensus cannot be taken to have been given willfully. Now, the next thing, very important, is undue influence. We saw a picture earlier on. I hope you remember that picture that we spoke about, where we said a doctor induces a patient to donate her farm to him for a few minutes before undertaking the major surgical procedure on the patient. Now look at this. Just a few minutes before the patient is to be taken for a medical procedure, under the supervision of this doctor. The doctor then says, sell me your property. Or rather says, donate, give me your farm. And sign these documents to confirm that you've given me the property. Certainly, that's a kind of, that's undue influence. You understand that undue influence occurs when, in circumstances where there is a special relationship between the two contracting parties. For instance, it could be a relationship between a parent and a child, a doctor and a patient, an attorney and their client, a pastor and their congregant. One party between these two has acquired a dominant position over the other. So, making use of that dominant position, he or she unduly influences and manipulates the weaker of the two parties to conclude a contract which is usually favorable to the one with a superior position between the two of them. Now, usually the people that manipulate others in this kind of a scenario take advantage of the intellectual weakness of their victim, or it could be physical frailty, some kind of sickness, or the trust between the two of these people. Because remember, we said parent-child, or we spoke about a patient and a doctor, as we have in this particular scenario. Let's suppose that the patient says no. What assurance does she have that this doctor will not then jeopardize her life during the surgical procedure? So as a way of trying to save her life, the patient the patient, ends up accepting that proposal for a donation, that request for a donation, makes the donation just so that she can save her life. Those are some of the evils of undue influence, and I guess you would understand fully while the law doesn't want to condone this kind of manipulative, obtainment of consensus. Now, we have come to the end of our discussion. I would like us to recap, just to remind one another of a few items that have been covered. In our concluding remarks, let us reiterate that though consensus is so critical to concluding of a contract, it is not the only source of contractual commitment. Yes, we say consensus is a very essential basis for contractual commitment, but strict adherence to consensus principle would lead to an inequitable outcome. Therefore, parties are held to be contractually bound on the basis of their declarations and their misrepresentations as well as representations. That concludes our discussion. But before we can call it off, I would like you again to look at what we have. Consensus is vitiated by or impaired by the following: mistake, representation, duress, and undue influence. Right. What about just some